Hey guys, John Ween, attorney and legal instructor with Blue to Gold Law Enforcement Training, coming to you today with another roadside chat. Today we have a question from an officer in Iowa, and the question is multi-part, but let's get started here. While serving a search warrant, can you detain/demand ID on third-party residents you may not have expected to be there while executing the warrant? A little further, if you have a valid search warrant for residence, and I know a specific person to live there by himself, when we go to execute the search warrant, there ends up being unknown third party at the home, friends, family. Can we make them stay at the residence while we execute the search warrant? Can we demand them to ID themselves? Okay? And so the short answer is yes. When you are executing a search warrant, you can detain anyone in the immediate vicinity who has a nexus to the property. Anyone who has a nexus to the property. The case that permits this is a United States Supreme Court case from 1981 called Michigan versus Summers. And in that case, officers executed a search warrant for a house, and while they were pushing up on the house, Summers walked down the stairs. They detained him for the duration of the search warrant, and while they had him detained, they located narcotics inside the house, and they also found heroin in his coat pocket. And the court said that this was okay. They said that this was permitted. They said that a detention during the execution of a search warrant is actually in everyone's best interest because it will keep officers safe. It will also keep the occupants of the home safe. It will increase the likelihood that officers will not have to damage the property to gain access to it. And so a Summers detention is what this is referred to. Another case that's on point is Bailey versus United States. That's a 2003 case. And basically what that deals with is this idea of immediate vicinity. And so when officers were preparing to execute a search warrant, they saw Bailey exit the home, and he got into a vehicle and traveled about a mile away, about 5 minutes drive. They detained him for the duration of the search warrant. Ultimately, the United States Supreme Court said this was not a valid Summers detention because a mile away was not proximate, that was not in the immediate vicinity of the execution of the search warrant, and so it was not a valid Summers detention. Now keep in mind, this might be a valid basis for a Terry stop based on reasonable suspicion. That is, specific articulable facts, more than a mere hunch to believe the person was, or is about to be engaged in criminal activity. And leaving a known house where you are about to execute a search warrant may very well be that reasonable suspicion. Obviously articulate more if you have it. Additional question. Another question. If you go to serve that search warrant and there is another person that is claiming to live there and has a separate room in the house that you were not aware of, are you allowed to search that person's room if you have a search warrant for the house? Or would you need another warrant for that specific room? And so this is going to be case specific, but by and large, the simple answer is yes, you can search that room as well. Case on point for this would be United States versus Ayers out of the 9th Circuit, or Hart versus Benton County Sheriff's Office, again out of the 9th Circuit. United States versus Kiles out of the 2nd Circuit. Basically what these cases say is that if an officer is executing a search warrant for a residence, for the entire residence, and while they are executing that search warrant, they discover that there are other rooms inside the residence that are owned by other people, the fact that another occupant owns that room does not by itself create a separate unit. What you're concerned about here is separate living areas that are distinguishable from the residence for which you have a warrant. Examples would be doorbells, exterior access, interior doors that are locked from the inside of that separate unit, separate addresses, separate mailboxes, things of that, right? Things of that nature. Courts have routinely held that just putting a doorknob or a lock on a separate door inside a residence does not create a separate residence. It's going to be a totality of the circumstances analysis, but by and large, unless there is significant distinguishing things that separates that as an entire separate unit, an entire separate dwelling, an entire separate domicile, it's going to fall under the purview of that original warrant. Hopefully this helps. Thanks so much. If you guys have any questions for us, go ahead and submit those to bluetogold.com/show, bluetogold.com/show. Until next time, I'm John Ween. Be safe out there and make good case law.